It's Friday afternoon. We've locked the door so we can reminisce about back when only weird fearmongers and crazy people wore face masks in court, and also because it's time for another edition of our weekly podcast, Tales from the Brown Desk. I'm Jake Rigney of Rigney Law LLC. With me as usual is my law partner, wife, and the angriest happy person ever, Cassie Rigney. Our host is Terry Alt. Friendly reminder, Tales from the Brown Desk is a free-flowing conversation involving two foul-mouthed attorneys. It may include graphic descriptions of sexual activity, violence, and nature's purse. It may not be suitable for children, adults, humans, aliens, or anyone else. We basically just do this to give Google more work to do. Listener discretion is advised. Here's Terry.
Hello, everyone. Hi, Jake. How are you today?
Oh, I am okay. How are you, Terry?
I'm pretty good. I'm happy it's Friday. Hi, Cassie. How are you today?
Hi, Terry. Fine, thank you. How are you?
I'm good. Yeah, thank you. So in this episode of Tales from the Brown Desk, we are going to talk about commonly asked criminal law questions. Questions that you've probably been asked many times over the years of being defense attorneys and prosecutors. And the first question is, what is the distinction between the types of crimes, the felony, a misdemeanor, and an infraction?
Well, those are the categories in Indiana that where the government can basically interject themselves into your life and try and guide your behavior. And the first distinction is civil versus criminal. Civil are like ordinance violations for not mowing your lawn, traffic tickets, those kind of things. And those are civil, and they're civil from criminal, because civil, you cannot go to jail for civil. It's a fine. You might lose your license if you do the wrong thing too many times, but that's an administrative thing. And again, it's you're not facing jail. Criminal distinctly means you can potentially lose your freedom, and that's why you get the protections there, because that's the ultimate precious thing that we all have is our freedom. And then for within the criminal side of it, you have misdemeanors and felonies. And misdemeanors are things that are punishable by up to a year or less, 365 days or less, and felonies are above. And then within each of those, there are categories.
Yeah, typically felonies are what you would consider more serious offenses. They range from sort of the minor serious stuff like theft, which could be not very serious, but also could be pretty serious depending on what was stolen and how much it was worth. Whereas misdemeanors tend to be often more sort of quality of life type crimes, for people who need to be taken out of the public for a day or so while they sort themselves out, but are not the kind of people that you need to put behind walls and keep away from everyone else for years.
Do you have the right to an attorney in all of these different types of crimes? Or like you mentioned infractions as a civil, so I know you can go and hire an attorney, but could an attorney be assigned to you if you have an infraction?
So let's start with the easier part. So with felonies and with misdemeanors, yes, because you can potentially receive a jail sentence, you have the right to an attorney. It's guaranteed to you in the Constitution, and there's case law sort of interpreting that. Gideon versus Wainwright was the big case that guaranteed the right to counsel for everyone. So even if you can't afford one, the court or the government will appoint an attorney to represent you for free. So we make sure that everyone who can potentially have their liberty restrained has the right to an attorney and has an attorney to look at their case. With infractions, because they are civil, you do not have the right to an attorney. You certainly can hire one. You have the opportunity to get an attorney if you want one to represent you, but you cannot go to the court and say, I can't afford an attorney, please appoint one to represent me, because it's not a criminal matter. Gideon versus Wainwright doesn't extend to infractions. which commonly include traffic tickets. So because of that, you do not have the right to an attorney in that situation.
Do the police always need a warrant to conduct a search?
No, there are a number of different ways police can lawfully conduct a search. One of the biggest ways to avoid having to do a search is consent. Or having to obtain a search warrant was consent. People can waive their rights, and they commonly do. So they oftentimes will try to get consent. And if you consent, then you waive a challenge to that. Now, an attorney later can challenge the lawfulness of that consent. Was it obtained properly and that kind of thing. But on the side of the road, yeah, you can consent and let them get that. Then there are other things, there are exceptions to the search warrant. A vehicle is a common practice where the law is established that if police officers find certain things, they can search that vehicle without having to go get a warrant first. And that goes down to technicality that, I hate to throw situations out because I don't want someone on the side of the road, trying to fight with police about whether or not they can get in their car, because as I've said before, those kind of legal battles are for the courtroom, and that's the best place for them.
Yeah, what Cassie's describing is called the automobile exception to the warrant requirement. There are a lot of different exceptions to it that have developed from case law, mostly Supreme Court case law over the years. And then there are also questions about there are also situations where they don't have to get a warrant just because the Fourth Amendment doesn't apply to it. For example, things that I don't have a reasonable interest in privacy rights over. So, for example, if they decide to search, Terry, if they decide to search your house because they think that there's evidence that will tend to prove I committed a crime, I don't have an expectation of privacy in your house. So they can still use whatever they find against me, even if they didn't get a search warrant, because I don't have any standing to complain about them violating your rights. I can only complain when they violate my rights. So that's another example. There's also a search incident to arrest. Whenever the police are arresting you for something, they have the right to search your person to make sure you don't have weapons or other contraband that you're going to sneak into the jail. So, and there are several other exceptions. We probably don't need to go through all of them today, but they don't always have to get a warrant, no.
How long does it take the police to get a warrant? Say that someone didn't consent and they're refusing, they're not being compliant with the search. If the police needed to get a warrant to conduct the search, what's the turnaround time?
I think this ultimately is jurisdiction to jurisdiction. This day and age, it's fairly quickly, and that's because, particularly with OWIs, they do warrant so much that it's established. There's a procedure established for officers to get in contact with a judge 24 hours a day and get those things signed. I can tell you in Marion County, couple 3 hours maybe. Then there are other, so it just kind of depends, but a couple hours. But if they think that they have probable cause, they're allowed to freeze the scene and hold the scene till they get an answer from a judge. Like, they don't have to let you go or let the suspected item they want to search go while they're waiting for that. They can freeze it while they're trying to get permission.
So does that mean there's a judge on standby at like 2 a.m. in the morning on Marion County just issuing warrants when the police request them?
Yes, absolutely. There is either a judge or a commissioner, which in Indianapolis is the, I don't want to call them assistant judges because they basically do everything that a presiding judge does, but and back when we had elections, they were the ones that weren't elected, but they are sort of an additional judicial officer that the court system keeps. I think there's 15 or 20 of them, and there is typically one of them on duty, or an actual presiding judge on duty, pretty much 24/7 to deal with officers' warrant requests.
I never heard of a commissioner. From what you just said, I'm assuming they have a law degree.
Yes, I'm fairly certain they do. The Indiana Code for Judicial Qualifications suggests that any person who's selected to serve as a judicial officer should have a law degree and 5 years of experience before they're selected to the bench.
So if somebody out there knows that they have a warrant for their arrest, what should they do?
Consult with an attorney first. There are a number of different ways that can be dealt with. Ultimately, you could end up having to surrender yourself to the police, but there are a couple maneuvers that an attorney may want to try before you get there. And then they can help guide you of, don't turn yourself in on Friday of Memorial Day weekend, maybe do it on Monday or, coordinate the surrender with the court, those kind of things. So I would say consult with an attorney first.
Could an arrest warrant be removed?
They can be recalled. That's the appropriate terminology. So, and you got to remember what a warrant actually is. It's technically, it's just a court order. And the court order is to the police to arrest this person when you find them, to bring them before the judge. And just like any other order, the judge can rescind that order if they're persuaded that it's reasonable to do so. So that's kind of how that happens. Occasionally, they're rescinded on somebody's promise to show up if they set a date or something like that. But sometimes they aren't either, and sometimes the person just has to turn themselves in.
When the police receive the warrants from the judge, do they go out looking for the person?
Again, this is not something that's going to be a hardline rule. I know for a fact Marion County has a warrant team that goes out and looks for people. I'm not aware that the other counties have that. But then certainly, I think maybe a county that normally doesn't do that, if they get an arrest warrant for a murder, you bet they may prioritize that and send people out to track them down. It's not an order for them to go out and actually search for you, but different police departments may have a procedure for that. But it's ultimately, as Jake explained, when they come across you.
Yeah, and I think it varies pretty wildly from jurisdiction to jurisdiction too. There are some jurisdictions where the police, I'm not going to say they're bored, but they don't have a lot of high priority tasks sitting in front of them, and sometimes serving warrants sounds a lot more fun than sitting with a radar gun trying to get people for speeding. So in some places, they will attempt to track down and serve every warrant they have as soon as it's issued. But in a larger place where the ratio of citizens to police officers is a lot higher, the police simply don't have the manpower to chase down everyone who doesn't show up for a misdemeanor. And in those situations, people often go months or years without encountering the police again, and there's just a warrant out for their arrest all that time. I've seen them go as long as 15 years without catching people who had warrants out for their arrest.
Wow.
So that happens too, and yeah, it's just really different depending on where you live and how bored the police are in your particular neck of the woods.
Well, and this brings up a good point. If you have an active warrant in one jurisdiction, you move across the country, especially on some of the low-level warrants, they may not bring you back, but you could get in this loop where your local police pull you in on the warrant, and they're allowed to hold you for 15 days. And then they could be told, well, we're not bringing you back. Well, until that warrant is dealt with, that could potentially keep happening every time you encounter the police. So it's consult with an attorney right away to deal with it, because it's got to be dealt with. It could, as Jake said, hang around and haunt you 15 years down the road.
So is there a national database of warrants so police in Florida know if somebody in Indiana has a warrant?
Yes, there is a national database. All the states cooperate with each other to provide the information, I believe, to the FBI, who keeps everybody's information. And so that way, wherever you are in the country, they will be able to run you and see if you have a warrant in any place else. That does not mean that that other place will come get you. But as Cassie mentioned, it creates a problem if you keep getting arrested on a warrant that they won't come pick you up for because you keep having to sit in jail over and over again, waiting for Marion County, for example, to say, to tell people in Idaho, yeah, we ain't driving all the way out there on a driving while suspended to come get him. Because that happens. People move away, they get arrested on the warrant someplace far away, and the sheriff decides it's just not worth the trouble. But the warrant doesn't disappear just because the sheriff won't go serve it. They eventually let you out of jail, but the warrant's still there.
Interesting. You could be let out of jail and still have a warrant.
Yeah, absolutely. Just in that sort of situation that I'm describing. If I got a driving while suspended here in Marion County and then I move to California and I get stopped in California and they run me, they see that I have a warrant, they'll take me into custody. They'll take me to the jail. They'll tow my car. They'll keep my car if I don't pay the tow lot fees. And then they will contact the Marion County Jail in Indianapolis and say, hey, we've got Jake Rigney out here in Oxnard, California. You guys going to come out and get him? Because we arrested him on your warrant. And Marion County will say, no thanks. We're not driving 2,000 miles to go get Mr. Rigney for that misdemeanor driving while suspended. And they're like, okay, well, thanks. And then they'll let me go.
With the warrant.
Absolutely.
So there's this website that I know you two are well aware of, the mycase.in.gov. It's a public database of many of the cases filed in the state of Indiana. Now, there are times when I've searched on there for a particular person who is incarcerated and they have a warrant, an active warrant. Why do they have an active warrant, but yet they're in jail?
It's kind of like a way for them to get in line. Like if someone's serving a sentence out of another county and Marion County has a warrant, well, they'll leave it active. So when he gets done with his sentence and that other county's done with him, they know Marion County wants him. It's a way to keep it active because the court's not going to go back and periodically follow up on these people. They're not going to mark their calendar, oh, John Smith gets out in 2027, so we better come back and, issue him a summons there. No, they'll put the warrant in, so it's kind of already in place. They don't have to worry about it. When that jurisdiction is done, he'll come and be under the jurisdiction of this.
What is a grand jury?
A grand jury is a panel of citizens chosen from a larger random group who sit and listen to the preliminary evidence and the investigation that the police have done about something, and potentially testimony from possible witnesses, so that they can determine whether or not charges should be filed. Now, Indiana is a information jurisdiction. So they don't have to do a grand jury. They can simply file a piece of paper charging a person with a crime and the person is charged that way. But sometimes the prosecutor decides they don't want to do it that way, either because they want to force someone to come in and testify so they can collect their version of the events. Sometimes people won't cooperate with the police, and so if you impanel a grand jury, you can force them to come and answer questions. Or in other situations, and this is just my opinion and me being honest, elected prosecutors might tell you differently, but sometimes when a case has a particular has a large spotlight on it due to media coverage or some other type of controversial subject, the prosecutor will impanel a grand jury to decide whether charges should be filed or not, so that nobody blames him for filing the charges, right? Because that way he could just say, look, we put it in front of the grand jury, and the grand jury decided to charge him. It wasn't me. I didn't do it. I'm just doing what they said to do. So those are sort of the two functions that it generally serves. And they can also issue subpoenas to make people produce things. So, but that's part of the prosecutor's office grand jury function. The grand jury itself is just a group of people who sit and listen to evidence and decide whether there's probable cause to charge a person with a crime or not.
Is there a specific number of people that make up a grand jury?
You know, it's funny because Cassie's like, don't ask me, I don't know. And she's waving her hand. And the truth is, I don't know either, because neither of us have seen a grand jury. They are secret. They are closed to the public. You cannot go watch one. So I actually don't know how many people are supposed to be in a grand jury either. Only the people who've worked in the grand jury division of a prosecutor's office, or maybe the prosecutor themselves, would know. Although it is likely all statutory in nature, so I'm sure I could figure it out if you wanted to give me 20 minutes to look it up. But having never attended a grand jury session, I couldn't tell you. It's probably 12.
Now, if somebody is convicted of a crime, how is sentencing handled?
Well, the easy way, if it's a plea, if someone has made an agreement, they're admitted, there is oftentimes what they call a plea agreement, and that oftentimes lays out what the sentence is. So what I think you're referring to maybe more so is like an open sentencing, a post-trial conviction. Now, the outside structure of this also controls what would be available to you in a plea, but generally we're talking about an opening sentence. The first place you start is, what were you convicted of? If you were convicted of an A misdemeanor, you're not going to the Department of Corrections. So the first thing, what level of offense is it? Second thing, when you go to open sentencing, the law lays out mitigators and aggravators. It says, okay, judge, what level of offense it is. It sets out what we call a presumptive sentence, and that's like, judge, this is your starting point. And then it lists mitigators, which are say, these are good things you need to think about. And aggravators, these are bad things you need to think about to move that from the starting point higher or lower, depending on the individual case. And then the judge would decide based on weighing those. And the lists and the law are not exhaustive. They're just kind of a basic list, but anything that the attorneys can think of being relevant could be brought in for consideration. But the big controlling is, what were you convicted of?
And can you modify your sentence?
Sometimes. It depends on several issues or several factors, including what you were convicted of to begin with. There are certain crimes where you can only ask for a modification in the first year of your sentence. After that, then you would be required to get the prosecutor's office approval to file that request. So it's a list of crimes that I think are commonly known as the violent crimes, although not all of the crimes on it are actually violent. For example, carrying a handgun as a serious violent felon is not technically, under the normal understanding of the word violence, it's not a violent offense, right? You just possessed a firearm when you weren't supposed to, but it's on the list of violent offenses. So if you were convicted of one of those, it's difficult to get a modification. The other time it is impossible to get a modification, I believe, is if you have, if you pled guilty and it was a set term plea agreement. So to understand the difference, you have to understand there's different ways to plead guilty. For example, you could plead guilty and everyone agrees to just change the sentencing range, right? If you're convicted of a level 4 felony, usually the range is 2 to 12, but you could agree to change the range to 2 to 6, right? And let the judge decide within that 2 to 6.
You bring it under 2?
No, because, well, yes and no. Technically, you can, because there's case law that says if you screw that up, you're stuck with it. But the judge isn't supposed to because the minimum sentence for a level 4 felony is 2 years. So the judge isn't allowed to give you a 1-year total sentence on it. Now, if they did, the Court of Appeals has said they're not going to go back and fix it, that it's just what it is. And okay, that happened. Too bad. Because it came up in what was kind of a really funny, well, not funny, I shouldn't say, but ironic case where a person, I think, pled guilty to a C felony. Back in the old days, a C felony carried 2 to 8, and the judge only gave him 1, and then suspended the 1 to like probation. Now, that's an illegal sentence. The judge shouldn't have done that. The prosecutor should have pointed out to the judge that the judge couldn't do that. But I think actually the prosecutor agreed to the 1-year sentence too. So everyone agreed to it at the time. But then the defendant violated his probation, right? And so he comes back and he's like, well, wait, you can't, no, because this whole sentence was illegal to begin with, Judge, so you can't give me the 1 year now on my suspended time because this whole sentence was illegal. You just have to throw the whole thing out and start over. And the Court of Appeals was like, no. I mean, it is an illegal sentence, but it's what you bargained for, so you're stuck with it, Chad.
Chad seemed to fail to realize that if they kicked it out, he would have been required to get a worse sentence.
Well, only if they convicted him again.
Right.
Who knows where their evidence had gone by then, and whether
True.
they could prove it or not.
True.
What is a plea agreement?
So a plea agreement is a contract between the state and the defendant about how they will resolve their criminal case that's pending. They come in lots of different varieties, including ones where you, like I said, you just change the range, and sometimes where you agree to every single aspect of what the sentence is going to be. And sometimes there's sort of ones in between that too, where you agree about some of the terms, but not other terms, and let the judge decide some things, but not other things. And you can get really creative, and it's so easy to get creative that I can't even sort of describe all of them. Every plea agreement is a little bit different. You kind of have to talk to everyone, all your clients, about them on their own, which is fine because that's what's required anyway of us, but it is at its base a contract by which everyone, the state and the defendant, agree about how their case is going to be resolved.
If somebody committed a crime and they decided that they're going to plead guilty, do they still need a lawyer?
I would recommend yes. One of the things is just because you did it doesn't mean that they can prove it. And taking the moral ground sounds good before you're in court being threatened with jail time. And I think a lot of people slow down, and even if you want to plead, that doesn't mean an attorney can't review the case and find weaknesses, or what I like to call pressure points, to get you the best deal. If you just go in there and spill your guts, what incentive does the state have to make you a good offer?
Yeah, if you're going to plead guilty, you are also you're going to have a sentencing hearing. And sometimes what happens at the sentencing hearing is more important than what would have happened during the trial, right? Because if a person has a bunch of mitigating circumstances that the judge ought to know about, you want somebody who can present that evidence in a way that's persuasive without being sort of mind-numbingly boring or without overdoing it. And generally, an experienced criminal defense attorney is going to understand how to do that in a way that a defendant doesn't, because there is not a defendant in the world who's seen as many sentencing hearings as a good criminal defense attorney has. Between my years as a prosecutor and my years as a defense attorney, I've probably done 10,000 sentencing hearings, maybe something like that. I mean, it's definitely in the thousands. Maybe it's not 10, but it might be at this point. That's a few hundred, that's several hundred a year. But when I was in misdemeanor court, I had 1,000 pending cases when I was a prosecutor. So no matter how many times you've been in trouble, no matter how many sentencing hearings you've gone to, you haven't seen as many as a good criminal defense attorney has. And so your defense attorney will be able to present that evidence in a way that's both persuasive without being burdensome, and that gives you the best chance at getting the sentence you want from the judge, because the judge typically has a lot of discretion. And it's gotten even better for defendants in the last few years since the code section has changed, or since the sentencing code has changed, and there are fewer mandatory minimums. That means that the minimum sentence for almost every offense is probation. Now, that doesn't mean that that's what everyone's going to get, but that is, especially for level 4 or 5 felonies and down, that's always the minimum. So it's good to have somebody on your side who knows how to deal with a hearing like that, so that you can put your best foot forward and give yourself the best shot of avoiding being locked in a cage for months or years.
Now, let's say somebody takes their criminal charges to trial and the jury finds them guilty. Does the jury sentence them, or is that left up to the judge?
That's up to the judge. The jury has one role and one role only, and that's to determine guilt beyond a reasonable doubt.
There's one exception to that. The one exception is the death penalty or life without parole. The jury does get to decide whether that sentence shall be imposed or not, but the judge can overrule them, although that is very rare, very rare.
What are some of the most important rights an accused person has?
I think on an individual, it's a case-by-case basis about which right is most relevant and important in your situation. I guess in general, the Bill of Rights is, that's the cream of the crop. There are the laws, trickle down from there to carve out other rights and protections.
Yeah, I think the most important one is the right to an attorney. But I'm an attorney, so I would say that because it makes me sound like super important and cool. And I like feeling super important and cool. But the thing about an attorney is that the rest of the rights don't mean much if you don't understand them. You know what I mean? The rest of the rights don't help you very much if you don't know how to litigate them in a courtroom, if you don't know how to actually fight using the Bill of Rights. And I see this more often than not in post-conviction relief situations. You don't have you have the right to counsel in a post-conviction relief proceeding, but you do not have the right to make them present whatever crazy idea you think. And so a lot of times the indigent counsel for those cases will review their post-conviction relief petition, say, yeah, there's nothing in here that constitutes a violation. You don't have a case. I'm withdrawing. And then it leaves them to represent themselves on PCR. And then they start doing the reading and they start trying to make arguments themselves. And they're usually nonsensical because they just don't have any experience with what these things mean and how case law works and how the rules of evidence work and the rules of procedure. And so you see them sort of making all sorts of procedural mistakes and creating all sorts of problems for their record doing that. And that's pretty common, unfortunately, in that arena. So that's, again, sort of why having an attorney is so important. Those things just don't, if you don't know how to file a motion to suppress and fight a Miranda issue, then you're going to lose your Miranda issue, even if the police violated your rights. Now, you get a little bit better shot with Miranda because the burden's on the state, but there are other ones where the burden is on the defendant. So, for example, if you're trying to fight a warrant, the burden's on the defendant to prove that that warrant's defective. A judge already looked at it and signed it. And it's very rare. It's not impossible, but it is very rare that you'll find a layperson within the confines of a jail or prison who has both the faculties and the resources to successfully litigate an issue like that. It's not impossible, but it is very hard.
I'm convinced the most important right you have is the right to an attorney.
Bail and bond, are they the same thing?
Yeah, there are two words for the same thing. It's what you have to pay to get out of jail, basically.
And how does bail work here in Indiana?
Well, the law outlines, so if you get picked up, they don't want people, low-level misdemeanors, something getting stuck waiting to have to see a judge. So there are local county rules. There's a lot of rules set up that say, okay, kind of run through this checklist, low-level offense, and they will go ahead and set a bond based on those rules. Just as due course. So that's, covers people so they don't get stuck over a long weekend or something like that. All these, COVID things, people get just processed out. But then if you have a higher level offense, you will be held until you see a judge, and then a judge will set it, and then you'd have to pay or produce, you can pay cash to the clerk or you can get a bondsman, but to higher level offenses, you generally have to see a judge.
What determines the amount of the bond?
There are a lot of factors that play into that. Typically, the biggest ones are how many times you've been arrested before and whether or not you've ever failed to appear for court when you were out of custody. And the reason is because bond exists to ensure that a person returns to court and that the public remains safe while the case is pending. That's the two main reasons why bond exists. And so if you have a history of either not coming back or committing new crimes while you're out on bond, then the court tends to place a much higher bond on you, either to give you a stronger motivation to stay out of trouble or understanding that you won't make it and you'll be held in jail while your case is pending.
What if you live paycheck by paycheck? Is that taken into consideration when that amount is set? Like, what if you can't afford $100 and you don't have $100 to spare? Is that considered?
It's one of the factors that would be considered, but your inability to pay does not trump the requirements that you return to court and the community stay safe.
So if somebody is released on bail, they have to return to court. It's kind of like a promise that I will come back to court. Is there ever the time where someone is released on bail and they may not have to go before a judge?
That does happen sometimes, because what happens when you're arrested is the police write down what crime it is they think you've committed onto a form, and they give it to the jail. And the clerk's office in Indiana will review that and set your bail based on what the police arrested you for, even if you haven't been charged with a crime yet. Okay? And you can pay that bond and then get out before the state decides whether they will or will not charge you with a crime. If the state then reviews the report that the police made and determines that they are not going to charge you with a crime, then you end up either going back to court just to find that out, or if you've hired an attorney, your attorney may find out ahead of time that you haven't been charged or that you're not going to be charged, and then you never end up going back to court. So it is possible. If you've paid a cash bond, you get that back when they decide they're not going to charge you with a crime.
Can the police arrest somebody without any evidence of their guilt?
No, they have to have what's called probable cause. That can be anything from testimony to video to DNA. But a credible witness could be enough for probable cause.
So I do see this from time to time where people just have a misunderstanding about what actually is evidence, right? Because it could include just what one person says to the police. It could include just a video. It could be all sorts of things. And some people have a tendency to assume that, just one person saying something happened isn't good enough. There's sort of the common refrain that's just he said, she said, or that's just hearsay. And the truth is that he said, she said cases and hearsay are allowed to be considered when it comes to probable cause. So if I tell you that I just got robbed, yes, that's just hearsay. You didn't see it. But that's good enough if you're a police officer to arrest somebody for robbery if I identify that person as the robber. Now, the thing is, if you're the police officer, you've got my name, you've got my phone number, you've got my identity. If it turns out I'm lying later, you can charge me with a crime. So it's not like there's no safeguard against people lying about things like that. But it's really good enough. It's not a terribly high standard. It's not real complicated. And there's a good reason for that, right? Because most people don't commit crimes in front of a big crowd of people or on video if they can help it. And we don't want to discount victims just because they were alone when the crime happened. And that makes sense when you're talking about every type of crime, right? It makes sense when you're talking about robbery. It makes sense when you're talking about women who've been sexually assaulted, or men who've been sexually assaulted for that matter. And it makes sense, when you're talking about police brutality too. It works both ways. Although I would expect the police don't take those claims quite as seriously as they do other he said, she said type claims. But I haven't ever worked in internal affairs, so I couldn't tell you for sure one way or the other. But the level of evidence that they need is low, but they do need some evidence.
If someone lies to a police officer, what type of crime is that, and what kind of consequences can come down on that person?
False informing is the name of the crime if we're just talking about talking to the police. It is a B misdemeanor on its own, essentially telling a lie to a police officer. It is an A misdemeanor if you told a lie to the police and it substantially interfered with an investigation. So it goes up a little bit depending on how big of a lie it was and how it affected the police. If you lie in court under oath, that's called perjury. That's a felony. That's a level 6 felony. So it depends on exactly how you did it and exactly what you said. And like I've mentioned several times before, every case is a little different and every defense is a little different too. So it's difficult to say exactly what would fall into what range. It just depends on the type of investigation.
Assisting a criminal could end up there too if you're not one of the people, like a parent-to-child relationship or something. That could get you if you were trying to cover up for a buddy or something and they found out that you lied.
Now, moving on to current events, the Indianapolis Metropolitan Police Department said earlier this week that they filed criminal charges against numerous people for making threats against officers, and this is all in the wake of the fatal shooting of Mr. Reed. As of May 19th, earlier this week, IMPD reported 26 threats against officers. What do you guys have to say about this? The public's pretty upset. Officers are getting threats.
Well, look, here's what I'll say. I don't know what happened between Reed and the officer that shot him to death. I don't think there's any dispute that a police officer shot, I don't want to mispronounce his name, but I believe it's Drayshawn Reed. Still, there is a way to register your disgust if you believe that there was police malfeasance, and that way is to protest. You can protest peacefully and reasonably, and there aren't a lot of things the police can do to stop you from doing that. But if you threaten harm to a police officer, that is not protected by the First Amendment. The police can do lots of things in that situation, including arrest you for a crime called intimidation. And if you threaten to commit a forcible felony against a person, it's a felony. If you do it while you're armed, it's an even higher level felony. The First Amendment does not protect what you call threats or fighting words. A lot of people think that freedom of speech means that you have the absolute right to say and do whatever you want, and that's just simply not true. There are limitations even to your First Amendment right to speak, and that's one of them. You cannot issue threats to people. So, I mean, obviously, I would love to know what actually happened, and hopefully one day the results of the entire investigation will be made public, and we'll all know or have a reasonable idea of what happened that day. Until then, it is not a good idea to threaten anyone about anything, and it won't be afterward either. It's just never a good idea to issue threats. If something really, really bad happened and Drayshawn Reed was murdered by the police, then the police should have to answer for that. But I don't know that we have the answer to those questions yet. And based on what I've read, and I haven't read everything about the case, but based on what I've read, I'm not convinced one way or the other at this point. And I think it'll be that way for a while. It's unfortunate. I wish that none of it had ever happened, obviously, and I feel awful for Mr. Reed's family that they've had to endure this. At the same time, I don't know whether the shooting was justified or not at this point. I've seen reasonable arguments from both sides, and I don't know all the evidence. So that's kind of where I'm at with it. Regardless of what happened, issuing threats is just unwise.
So Indiana is not the only place police receive threats. Florida man threatened the police. He was coughing and spitting on officer's face, claiming that he was infected with coronavirus. Florida man was later then indicted on federal terrorism charge. Florida man's defense attorney says that the prosecutors are stretching the law here. A law that's meant for terrorists to cover a run-of-the-mill police encounter. Yes, it's run-of-the-mill in Florida police encounter. The Florida man's defense attorney also says that the United States attorney's position in this case would make millions of COVID-19 patients in possession of a biological weapon. Do you think this is a good stance for this defense attorney to take?
Well, look, I don't think his first argument is very persuasive. I would not call attempting to spit a potentially deadly disease on a police officer a run-of-the-mill police interaction. I've had several interactions with the police, and not once did anyone think about spitting on each other, including the officers or me. So, I don't think that makes sense. Although his argument regarding the fact that if you say a person having COVID means that they're carrying a biological weapon, that may have a point. But in federal court, it's kind of a different story. I haven't read those statutes, so I don't know how broad or narrow they are. But that second argument, at least, is interesting. The first one is, I guess politely I'd call it puffery. It's defense attorneys have these weird options, right? When the media contacts them about one of their cases. And the first option is they can say things like no comment or I don't discuss pending litigation. These are invariably, that is the right thing to say. It is also extremely boring. and
Yeah.
it does not get you any new clients.
Right.
On the other hand, saying some crazy stuff like this was a normal routine police encounter, like people just spit on the cops every day.
He is in Florida.
Well, look, I mean, I've been to Florida too. I even had an encounter with a Florida police officer once in a DUI checkpoint. Now, I was very drunk, but not driving. So, haha. But once again, no one spit on anyone in this encounter. And by his logic, I apparently got real lucky. But so that is a silly thing to say on one hand, right? On the other hand, it sounds cool, doesn't it? It sounds like he's trying real hard.
It does.
Sounds like he'll try real hard on my case too.
Mm-hmm.
Yeah, that's what it sounds like. So I would be wary of anybody who makes comments like that to a newspaper because, first of all, you've broadcast your defense to the other side, right? Usually better if you let them guess about what your defense is or let them worry about more than one thing. Now all they have to worry about is this rather silly defense that he's proffered in the media. Or better yet, you could have proffered the silly defense and just hoped it caught them flat-footed and they didn't have anything intelligent to say about it later. And now you've spoiled the surprise of it by dropping it in the media. So either way, it was a bad idea to do it. In Indiana, in fact, you're not supposed to have any comment at all in the media about your cases. There are specific rules about pretrial publicity that attorneys sometimes pay attention to and sometimes don't. And that includes, unfortunately, the prosecutor's office sometimes. So it is typically a bad idea, but I bet his phone rang the next day after he did it.
So Florida man is not only threatening people with the coronavirus, he was tested for the coronavirus and it was negative. So it was...
So he false informed as well.
He false informed.
Now that would be a misdemeanor, false informing, because I bet you the police officer then had to go get tested and had to be quarantined, and it probably substantially impacted their investigation. So in Indiana, you do that, that's probably an A misdemeanor. Not cool, bro.
So earlier this week, Florida man was woken up at 6:30 in the morning by his dogs barking. The dogs trying to alert him to a threat. So he makes his way to the kitchen where he finds another Florida man standing there, a complete stranger, and he's naked, completely naked. And when he sees the Florida man, owner of the home, naked Florida man grabs 2 knives and then bolts out the door. And then the police officers find him not far away, and he was hiding in a nearby screened-in porch under a swing. It was reported that he's on drugs. What kind of drugs makes someone do this?
All of them.
No, I don't know.
Acetaminophen.
Most of them, if you take too many. I mean, I'm serious. If you take enough, marijuana won't kill you, but you might start hallucinating eventually.
Yeah, that's the funny thing. People say that you can't overdose on marijuana, and it is true that you cannot die from a marijuana overdose, but you can absolutely overdose on marijuana. And typically you experience what's called psychosis from it, where you become very disturbed about all sorts of things. So look, it could have been marijuana. It probably wasn't opioids, but I suppose it could be. Look, everyone has weird reactions to these drugs sometimes. So it's hard to say. It's hard to say what he was on. But on drugs is a pretty good guess, I'd say. Yeah. You don't usually do that. Why the knives is what I wonder. What was he going to...
I wonder if he didn't know where he was, because I mean he grabbed the knives and fled. So I mean he wasn't taking an aggressive stance.
Yeah, you think he thought he was in his house and he was like, I'm just going to run away. I'm not going to defend, but I'm going to take the knives. I don't.
Well, do you want to go into a fight like that naked?
I don't want to go
in your home or not, whether it's your house or not.
Well, I don't want knives involved in the fight if I'm naked. That's a lot more likely to result in Lorena Bobbitt situation.
Here we go. We're trying to apply logic to the Florida man situation. We will always lose.
That's right. Yeah, I'm sure he didn't think about it that much, or he did, but it was because the silverback gorilla on his left shoulder told him, "Bring the knives, dummy."
2 of them.
I like hiding under a swing. That doesn't sound like it'd give you much cover.
Right. I'll just curl up in here. They'll never find me.
Well, if I don't move, they won't see me, right?
Right.
Yeah. How did?
Don't ask the question.
That wraps up this episode of Tales from the Brown Desk.
All right. Thanks, Terry. And thank you for listening to Tales from the Brown Desk. Please remember, while we may discuss legal issues and provide information regarding the law to our listeners, we do not intend to create an attorney-client relationship with any listener. Our advice may not be applicable to some legal issues. Please consult with an attorney you have hired to review your legal situation before you attempt to apply the things we have said to your case. The attorneys at Rigney Law do not comment on their current pending cases. Nothing we have said in this podcast is a comment on a case we are currently working on, even if your name is Chad or if you are a man from Florida. Thanks. Take care, everyone.